This is AM 650's The Law Show with Sterling Fox. Now back to the show.
Good to have you with us on this holiday edition of The Law Show, right smack between Christmas and New Year's. David Hobbs and Ian Giroday from Hobbs Giroday, LLP in Vancouver. Vancouver estate litigation lawyers with offices downtown right across the street from the courthouse on Howe Street. Online at hobbsgiroday.com, and you can contact Ian or David. Simply go to the website and all the contact information, the email addresses, the phone numbers and everything right there at your fingertips. Talk to us a little. We talked about the wills, the construction of a will, and what the courts will accept as a legal or valid will. What happens when a person dies and there isn't a will? What the courts do? We have this law, this procedure in BC that automatically kicks in. So when people come to Hobbs Giroday, you don't draw up wills. Other lawyers do that. You see people who are unhappy about the content of wills. Is that a safe statement to make, Ian?
Well, it's one of the reasons people come to see us. There's lots of different types of estate litigation, but a very common prospective client who comes to see us is someone who feels like they've been disinherited or not treated favorably under the will.
Okay.
Want to know if they can do something about it.
Okay, and they would apply for something called a will's variation, David, and a variation is the legal term for a change. I want the will varied. I want the will changed. Correct?
That's correct.
Okay, what are the other forms? Ian said there were other forms of clients who come to you, other types of clients with other issues, aside from perhaps feeling slightly less than equal among their siblings and peers. What would some of the other issues be?
Well, if we leave aside validity of wills.
Sure.
So let's just assume we've gotten past that.
Right.
It's a competent testator and nobody unduly influenced. The lawyer helped them draft the will and sign it, and the will looks good. So
right.
That's not the discussion. We've talked about will's variation, which is a common variety. Then you may be into issues regarding administration. No one's getting on with the administration of the estate, or the handling of the administration of the estate is contentious. Maybe the executor who should be getting on with the administration lives in the house that's supposed to be sold and distributed, and they're dragging their feet.
Isn't particularly interested in changing address.
They don't
right.
really want to upset the apple cart that they're sitting in.
Sure.
It could be a concern about expenditure of the estate. Maybe the executor's driving around in a brand new car and you're wondering where the money came from to allow that activity. It can be, so that's about things that what we refer to as accounting, because executors have to pass their accounts at the end of the process of administration, and you would want to make sure that the money is being spent appropriately and accounted for. And so it could be about those types of issues. Those are, and I'm probably many more, but those are the ones that quickly come to mind.
You know, when we're talking about, Ian, estates and the wishes of people who are advanced in years, and in many cases they'll say, well, I'd like my brother or my brother-in-law to be the executor of my estate. Well, my brother-in-law isn't much older or younger than I am, right, and getting on as quickly as I am day by day, and perhaps by the time I pass on, my brother-in-law is perilously close to doing the same thing and isn't going to be much help to my estate as the executor. What happens then?
Well, it's very typical in a will to appoint an alternate executor.
Oh, really? Okay.
Or co-executors. And if the brother or brother-in-law doesn't feel up to the task,
right,
they may renounce and say, I do not want to be the executor here.
And that's legal. That's allowed.
It is. They can't get too involved in the estate before they make that decision.
Okay.
That's called intermeddling, and then they may be disqualified from disqualifying themselves or not carrying forward with the task.
Okay.
Now, then it would fall to either just the remaining co-executor, if co-executors were named, or the alternate executor. And if no one named in the will is willing to act, then someone else can come forward and apply to the court to be the administrator with will annexed. In other words, there is a will there, right, it's valid, but no one appointed in the will wants to be the executor, so someone has to step forward.
And the court will do that?
Yes.
Okay. Talk to us, David, if you would, please, about people who come to you and want a change. They want a will varied. This is just wrong. I've been left out. It must change. So you accept the case. what do you do? How do the wheels begin to turn once you've decided that the case has merit and that you're going to represent this person at trial if necessary?
Well, if there's real estate in the estate, we'll probably be thinking about filing a certificate of pending litigation. But those words mean that there actually is an action that's been started. So we're going to commence an action in the Supreme Court of British Columbia on behalf of our client, wife, common law spouse, adult child, infant child, through a guardian ad litem. They can't.
Right.
They need a representative. But we're going to commence an action. We're going to have to name everybody as defendant who has an interest in that estate, executor, all the other beneficiaries, anyone who has a right vis-a-vis that estate. They all have to have notice and have to be named. So the action is commenced. Wills variation actions are a bit unusual because the limitation period is very short. If there's been a grant of probate, you only have 6 months to commence the action. So it's a decision that's made and acted upon relatively swiftly. And then you're going to have a lawsuit commenced. You may have some property with some certificates of pending litigation filed on them, and you'll then begin the process of litigating that matter.
If, and I'm sorry to interrupt, but this occurs to me that we're a fairly well-traveled bunch these days. Suppose now the probate is granted, the will, the execution of the will is begun. So now I've got 6 months to apply to have a change or a variation made to that will. But I live, in Southeast Asia. I'm on business 6 months of the year. I didn't even know the guy died, let alone have an opportunity to apply to or to intervene in any way. Am I just out of luck because I wasn't physically around to get any of this information or take any action?
Well, the process of applying for the grant of probate includes a process of notice.
Oh.
So the executor has to give notice of the intention to make the application for a grant of probate. And the idea there is to ensure that anybody who may enjoy rights, including the right to sue for wills variation, has notice. And to get the grant of probate, the executor has to satisfy the probate registry that all the notices went out, and everybody that should have been notified and might have taken a position is aware. It's not a completely foolproof system. There can be cracks and things can slip through the cracks, but generally speaking, there's a notice process to prevent the thing you're talking about.
Yeah.
And sorry to ramble on, but sometimes people who die have children that the family doesn't even know about.
Absolutely.
And so you can get into strange situations of people popping up and saying, hey, I'm the child of that person. Everybody goes, I've never heard of this person. What is this all about?
And do courts make provisions for these unexpected, untimely arrivals of unknown parties?
Yes, there can be a situation where someone should have got notice and didn't, and they explain, well, I'm the long-lost forgotten child, and that might be the exceptional circumstance where the limitation period might be extended to accommodate that person.
Ian, I wanted to ask you about the job of being the executor. I looked it up on the internet, and my gosh, it goes on and on and on and on, and there's lots of information there. But I tried to soak up as much as I could, but it gets pretty sort of dry pretty fast. And none of us, I would imagine, who are appointed or requested to be executors are law school grads. So one of the things that you do at Hobbs Giroday is work with people who are executors, who are lost in that internet thing trying to figure out exactly what they're supposed to do. You can help them just focus on getting the job done and quickly.
Sure. There's, of course, the first order of business is to actually get the court's blessing to be the executor. In other words, the court will recognize the will as being the last will and you as the named executor. That involves filing papers with the court registry, which are, frankly, is quite foreign to a person on the street who might be appointed executor.
I agree.
And an executor is perfectly entitled to reasonably use the services of a lawyer for legal issues and the services of an accountant for accounting issues like filing terminal tax returns and obtaining clearance certificate from the CRA and so forth. So
And-
yeah, we can certainly help out.
And if the
executors.
executor incurs some expenses or runs up a tab with the firm, learning his or her job and getting the estate settled as quickly as possible, but would the fees that would be charged to that executor, would the estate pay for those fees as part of the executor's responsibilities?
Yes, and I mean the executor, once they have access to money, and they may need the grant to get access, or they may have access to some money. Banks sometimes allow executors who have a will but have not yet obtained the grant to use money for some specific purposes. You know, insurance is always a big issue. You want to make sure all the assets that need to be insured are insured. The house doesn't burn down awaiting the grant of probate. So the bank might allow you to withdraw some money to pay an insurance company to issue fire insurance over the house, for example.
Pay the bills.
Pay certain bills. And that would be, so you'd have access to the money for a limited purpose permitted by the bank because you show them the will, you're in the process of applying for grant of probate, and you want to protect the assets.
Need to take a break here, but let's just end on this segment, at least, on this business of being the executor. I've never had it happen to me, but I expect it will eventually. Someone, I know who, is going to ask me to be the executor of his estate. I don't know how keen I am to oblige. It's my brother. I expect I will say yes, but this is an alien world for me. Instantly, I'm thrust into an environment that I know nothing about, despite my best homework on the internet. So, can I say no? Is it, I mean, obviously, if someone says, will you do this for me? And you can say no, but if someone asks you to be their executor, I mean, that's weighty stuff, and you'd feel bad or guilty about saying no. But if you don't feel up to it, Ian, should you say no?
You should, because I think a person who does all this estate planning should have an executor named in the will who has given an indication that they will do the job.
Right.
You know, and otherwise, one of the very purposes of preparing a will in the first place, which is to organize your affairs and appoint a person to
take care of biz.
Done,
right.
That's lost.
Okay. So, and a final note on executors, David. Any person could be an executor, and family members are also wide open and eligible to, even if they're named in the estate. The oldest son, for example, can very well be the executor of mom's estate.
Yeah, typically a beneficiary and a family member is also the executor.
Okay. And if you find yourself in the somewhat awkward predicament of being asked to be an executor and would like a little bit of knowledge as to what responsibility you're agreeing to assume, go on the internet, do that. It's, useful, but I would recommend perhaps a face-to-face with a lawyer to find out exactly whether it's the kind of assignment that it wouldn't take long sitting down with one of you two for a person to go, I've been asked to be an executor, and I don't want to. But, it's my brother or whatever. What's your best legal advice? You would talk to that person, wouldn't you?
Sure, and just explain to them the duties and the risks.
Right.
It's a job.
Yeah. Know where you stand at all times. Mm-hmm. Okay. This is The Law Show on AM 650, and we'll be right back.
There's more of the show still ahead. This is AM 650's The Law Show.